Looking on the other side,
Item
19 lot.
19.
I have to file an affidavit lot. My affidavit is ready lot. I am filing by couple of days.
Item 19.
Let me after a week.
Okay. Mr. N. Vaidhana, learned standing counsel for the irrigation, means that affidavit is being filed within a period of
1 week.
from today. Affidavit in opposition. Accordingly, 6 and prayer is allowed. Please after a week.
Obliged.
Yes.
My note is partner to bring on record an affidavit in respect of item 40,
Please.
item 40.
Why is
My lord directed us to bring on the original newspaper.
okay?
We have filed it with them.
May I please? Item number 4, my lord, I am appearing from Mr. Etc. Dr. I have taken the question of harm to be taken up in
Access for after yeah, prayer is yeah. When?
next week.
After 10 days.
To mention item number 26, I have, our client has instructed me to do this bit.
20?
Six.
26 MSB does. Which put up on with the perimeter.
Five.
Item number
60.
16. Yes. You are for the petitioner. You are T. Dekha on behalf of J. Kalita. Just. Yes.
I am the petitioner of item number 7, 8,
7 and 8. Yes.
with the purpose of the other matter with item
How then it in it? Phone number to let you. Please this bit 9. Item number 9. Please this matter before any other way.
item number 7, 7. Item number 7 and 8.
7 and 8. I have adjourned it. 9 not different.
Please kindly recorded my senior name, item 8, estimate.
He is here in Guwahati. In the High Court premises, he is
Yes.
there. Estimating. Estimating for whom? Item number 8.
Eight.
Oh, 7 and 8. 8 only. Not 9. Item number 8.
8.
Okay.
7.
May I please pursue my petition item number 20 to adjourn the matter.
Why? Why you wanted an adjournment? Tell us.
As my senior me to
You do not know the reason.
senior is not
Senior is on behalf of the FPN. Yes, next.
May I please? By recommendation item number 2 dot. Here the matter is
You are Mr.
Mujumdar.
P.
P.
Mojumdar.
Item
In Foxworth,
of the
the thought is great. Correct.
May please.
Yeah.
Lord, I pray for adjournment of it be done for just a week, Lord. After that, if it's not prepared, but certain personally, after a week, let's come after a week. But I'll appear.
The prayer of the Lord. Have you taken consent?
Yeah. I put 2 minutes.
What is this method?
He is challenging our appointment of the supervisor in the special budget.
Any stay?
No.
Okay.
2005.
2005.
Litigations have been filing continuously 2015.
So let us conclude the litigation.
No, various litigations. So I'm also, I
therefore-
also came. Because agree.
2018 you should be ready next week. Please, Dr.
Please, Lord.
Yes.
I beg to confirm item number 41, Lord. Yeah, Lord, the order has been complied.
41. Mr. H. Talukdar, Learned Counsel for the petitioner. Mr. That's all. Okay. Yes.
Earlier, please, that there was a now I have permission for 2 weeks time.
You have the Learned Legal Counsel.
I'm the
M. The practice judgment and release the doctor. But sometimes Soli has name is known. It's Soli. Wait for some.
Matter of interest.
Hmm.
If the total transferred and it got not to check out, we have written a letter
What is the order?
photo was 18th October.
You said for which is the department?
Revenue and Disaster Management Department.
Their issue is they are claiming the benefit under Kobiram Rajbongshi and Nauman Holita. Now, court simply says you file a fresh representation, they will consider whether you are entitled under the benefit of Kobiram Rajbongshi and Nauman and dispose of within 2 months. This was an order passed on 27/7/2018. We are in 24. So if anybody is from revenue is there,
I can buy.
we can dispose it of at 2. We know that this has become infructuous. Otherwise, client would have. Well, this matter should not be kept pending. Yes, next.
At two.
Not at 2, you wait for some time. If somebody comes, we will ask and then we'll again fix it. Consent. Next.
I'm agreeing for the full respondent.
Hmm.
I have to implement a new income tax. But I gave that post on 15/12/2019. As far as my action is concerned,
Hmm.
actionary is not cooperating with the authority.
What is the
He was
order?
asked to submit certain documents for finalization of his pension. But
None appears for the petitioner on call.
next is, he wrote to the authority that he is unable to provide the document.
None appears for the petitioner on call. None did represent the petitioner when the matter was called on 13/10/2023. Full stop. A submission was made. No, order dated 17/7/2023 reflect that a submission was made by Mr. M.K. Shah, learned counsel for the petitioner, that the learned engaged counsel, Mr. N.N. Karmakar, had expired in the meantime, and therefore the petitioner is required to make alternative arrangement. Accordingly, prayer of adjournment was granted. On 13/10/2023, this court directed the registry to communicate the petitioner about the order dated 17/7/2023 as well as order passed on 13/10/2023. Office note dated 19/10/2023 reflects that the petitioner was communicated with a copy of order dated 17/7/2023 and 13/10/2023 by memo dated 19/10/2023. However, there is nothing on record to show whether the petitioner has received the appropriate communication. Registry may verify regarding status of service of the appropriate communication and put a note in this regard. Mr. Borua, learned counsel for the respondent, has submitted that the respondent, sole respondent, could not comply with the order as the petitioner did not cooperate with the respondent employer. Respondent employer did not cooperate and did not submit the required documents like photograph of legally married, joint photograph with the legally married wife, and birth certificate of all the children born in the wedlock of both the wife for finalization of the pension. Full stop. Mr. Borua has also brought on record a communication whereby the petitioner has replied that he cannot furnish such documents. Be that as it may, list this matter. Be that as it may. In the meantime, the present respondent has also been
He has to be completed.
and he has retired.
No. He's in another place.
Okay,
He-
present incumbent has also been transferred, and therefore present incumbent is to be implemented in this regard. Be that as it may, let this matter be listed once again on 1st of March 2024 with the office note as directed herein. Let us see.
Really, problem is that he is having to work. Some
But
dispute is with
But why provision for his provisional pension? He may have 2 wives, 3 wives. Pension you will give.
the provisional. I guess provisional he is getting for finalization.
No, for finalization. Why do you need? That will arise after his death.
In the PPO itself, only, that wife's name will be reflected, because in that PPO itself, if he dies, his wife will get the pension. He
Okay,
has to
let us
provide. And that case was also disposed of in the motion stage. That's why these things not be brought into
that is the difficulty. That's why we do not nowadays. Okay, next case.
of like In this matter, my lord, the process gets come. Respondent number 9 and 12. We have already, my lord, communicated with Deputy General Manager at law. So only, my lord, if the standing council gives the comment, my lord, that take a communication, then, my lord, the official date of number 9 and 12, my lord.
To tell to non-appears, wait for some time, call somebody. Call somebody, APDCL. There are some other matters. When these matters are called, then call them. Yes, next. Yes, Saliha. These were midwife and auxiliary nurse, something, ANM. Auxiliary nurse and midwife.
Lord.
Now they approached this court. They were overaged for selection. So they had twofold prayer.
Lord.
First is that our age should be condoned. That was rejected.
Lord.
Second prayer was that our case for regulation shall be considered.
Lord.
Court says, okay, you consider.
Lord.
And this was of 2020, 17, 11, 23.
Here I'll have to,
Have an telephonic instruction.
yes, Lord, Lord, the copy of the,
You go through it.
yes, Lord.
Go through it, have a downloaded copy.
Yes, Lord.
Just have an instruction.
Lord, maybe the speaking order has been passed.
That has been passed. That's why nobody.
Lord.
Huh?
Lord.
You will have it duplicate too. Yes. Go through this. Keep
Lord.
it. Huh? Yes.
The party not good of happy represent.
What is the order?
Order dated 9 and 20 file the affidavit. However, the state affidavit is not connected to the case. We need 1 week time for filing.
Affidavit file.
They filed the affidavit. They have filed, but we need 1 week time for filing affidavit in plan.
Why?
My senior could not appear because it's technical.
We'll relieve him from his anxiety. One more anxiety. Speaking order is passed.
Yes, my lord.
What is that page 42 in affidavit?
I have given my two of them have been one of them has been terminated, my lord.
What is your name? Taher Borbhuya.
Yes.
So Basir Ahmed Borbhuya, one increment. What about Taher Borbhuya?
My lord, Tahir Borbia is the president of Tokinda Panchayat, my lord.
No, your direction was issued to consider his representation.
Yes,
Where is that?
my lord, till now we have
Till now?
next week, my lord.
What next week? So you have done a contempt then.
Next week, my lord. I think I'm not out of my lord. Just next week, my lord. In Friday, my lord, or Monday.
You have said you have passed an order. Where is that order? You have been terminated. Your contractual job is terminated after the representation. Where is your representation disposal? Termination is different. Where is your senior?
My is out of state. He's in Delhi for medical checkup.
When is he coming back?
He's coming back in Wednesday, my lord.
Friday. Please this matter on Friday. Under prayer of the learned council for the respondent. So as that he has filed a representation and you have disposed it of. And his representation is within a specific period. That's all. There is no writ of mandamus. None appears for the petitioner on both. In view of office note dated 7/2/2024. Petitioner to take fresh steps for issuance of notice of correspondent above. List of the corrects. Yes, learned counsel for the petitioner press for and is granted 2 weeks time to take steps upon respondent number 3. Learned counsel for the petitioner submits that they are required to impeach the present incumbent after putting the present incumbent to notice regarding the order in or non-implemented in a order in which accordingly she prays for 4 weeks time. Prayer is granted, please come.
May please your lordship, time that
Learned counsel for the petitioner prays further 3 weeks time to do the needful in terms of this court's order dated 30/2/2020. Prayer is
oblige
please 2 weeks. Yes,
This contempt is for non-compliance of the order dated 30/11/2021, which is at page 9. Page 9. The basis of the instruction furnished by the Parliamentary Council notice order was passed.
Hmm.
In view of the above discourse of the opinion that a time frame should be provided to the respondents to consider the petitioner's application. The departmental screening committee is thus directed to consider the petitioner's claim for professional appointment
Hmm.
in its next sitting.
now that we have read now,
I submitted the court order on 3/12/2021, page 11. Page 7.
now why this matter is listed, who is representing notices
I am
and
for question number 2, my lord. But this order, my lord, could not be acted by you, my lord. Why, my lord, kindly see page number 22 of my affidavit.
page number,
22.
you have filed affidavit.
Yes, ma'am. 22 and 23. This both has been abolished. We have intimated the petitioner also. Okay, it was the case of 2018. In between 2018 to 2021, several opportunities were given to the Departmental Council for taking instructions. And on the basis of the instruction, this order was passed. And subsequently, this was the communication. So there is clear violation of court order.
No, that those are fine, but where is the question that they will have to appoint in a compassion
No,
against a
there is some
specific post?
There's some miscommunication, madam.
Huh?
Some misunderstanding.
Where is that direction?
There is no, sorry,
If
madam.
no direction, where have you found that they are to be appointed against some abolished post?
No, kindly see, madam.
What is your direction? You need to consider their case by the screening committee.
No, madam. Kindly see, madam. Para 3, madam.
Huh?
Para it was-
Application for compassion would be considered by the departmental screening committee as and when they see.
Now, madam, kindly see page number 22, para 3, madam. Para it has also been clarified by so and so.
Yes?
Page 22, para 3, madam. Para 2 is also important, madam. In this regard, it is kindly
Page
submitted
22.
of the affidavit. It was kept in whole. In this regard, it is kindly submitted that all field officers of CWC regional officer have been directed to CWC headquarters New Delhi that on the advice of Ministry of Water Resources, and so it has been declared the CWC headquarters that all the equipment workers may be kept on hold by all the field organizations of CWC till the further order so and so. Further, it also been clarified by letter so and so that the convening of meeting professional appointment committee with the post of work count CWA in the respective circle office amounts to non-compliance with the direction of CWC New Delhi. Hence, it is kindly be intimated the case of appointment
Okay.
of
Your
will be considered as and
your-
when the equipment workers is uphold, or it was not uphold, it was abolished subsequently in page number 23. So we are preparing a review of this order. And it for
Lordship,
51.
despite the pendency of almost 4 years, Lordship, state instructions were not furnished. Moreover, Lordship, there is a question, Lordship, whether this communication is will have a retrospective or prospective effect, Lordship. My father died prior to application of this letter, Lordship, and I
What was your father working? Work sergeant,
Okay.
Huh?
Skill
Oh.
workers assistant.
regular.
regular. Now, what is the compassionate appointment scheme said?
It is to be 1 year, page 20, kindly see.
No, forget about 2 years. It has been given for your consideration.
Yes.
Can't you make a consideration even?
No, kindly see.
And say all these things? Are you taking this this court to be a compassionate appointment
No, 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 no.
committee?
Obviously, no, kindly see.
Then if, what was the direction?
Page 20,
You are complicating the matters.
that's why we are preparing a review, of this order,
What reviews to be done? They say you sit and decide. You take all this decision. Who has debarred you? Then we'll test this order whether it's correct or not. That's all.
This was communicated to the petitioner also. It went 20 itself.
Not done that.
this is not consideration.
From 80 May, it was kept in whole mile.
Don't argue beyond.
Yeah.
If you want to bring it, is your committee above High Court?
No, obviously not. Obviously.
Above High Court?
No,
That
no.
some committee has said not to do, then you will not. Forget about High Court order. If you are arguing that, we'll take the dictate order right now.
No.
If it is your argument,
No. That,
then why you argued all those things?
I am just indicating to one.
No, don't indicate. That letter itself is a contempt. A simple order is passed. When the screening committee sits, his case should be considered. You are saying that we will not consider his case because some committee has said not to do this. So forget about High Court's order. Our committee is higher. Tell us that. No, not. You need not be argument. You may not even hear you because it's a contempt between us and the contemptor. That document itself shows. Page 22.
Yes.
Why will not draw a difference to moto contempt on this? Tell us.
Kindly see, he is just an executive engineer.
He is not fit to be an executive engineer. Yeah? If you say that executive engineer can sit over and
No.
express his views that forget about
No.
High Court. I am concerned about my chief engineer. Forget about High Court.
That's not my opinion.
No, it should not be your argument. Your document says itself. Or unnecessarily you are complicating the issue. What is your right? If they say that no, where is the direction? Let us see.
Page 9.
Page 9.
Yes, and
Where is the contempt?
Lordship,
They are saying court has directed next sitting. They are saying there is a direction not to sit, so we are not sitting. When they will sit, they will do. Where is the contempt? Tell us.
Lordship, they clearly stated that they will not be when considered by metal. As per Lordship, it's over page number 22 is concerned.
So they say we will not sit. That's all.
Lordship,
As and when sit.
and there is
Court has not said that you sit. They say as and when. Where is the contempt?
Lordship, paragraph number 6 of the court order. Lordship. The Department of Screening Committee is thus directed to consider the petitioner's claim for compassionate appointment in his
In the
case
next sitting, along with
Along
all
with
other
all other
eligible, they are
eligible-
saying we are not even sitting and no eligible.
Which
We are
shall
not
be-
taking consideration.
which shall be done not later than 3 months from the date of receipt of the certificate of the So the clear direction.
Suppose they have abolished that we will not have any scheme of compassionate appointment. How will you do that?
And again, Lordship. So Lordship, I kindly
Yes,
say that
yes. What will you do? Tell us.
Give me some time.
synopsis of the report will be very Lordship. My father expired on 12th 2016.
Oh, Mr. Synopsis of your order. What is the order? We are in a contempt. What the order says, nothing. The prayer of the learned counsel for the respondent methods and adjourned and be listed on. Don't file anything and everything, whatever your client. Advise them properly.
After twist,
Your page 22 may create you in, put you in trouble. I'm telling you. That is not the way.
I'm like, that this matters, but the sale my lord non-payment of gratuity leave. The order has been partially complied. I would like to file affidavit. Substantial amount has been released, my lord, including gratuity, leave salary, my lord. Their salaries are pending, my lord. The area salaries, my lord, fund demand has been raised before the government.
Pension, gratuity, leave salary, and past area. Now, what are being paid?
The, my lord, gratuity and leave salary, my lord. And
What
past,
about
past salary, my lord, this fish pay is no more profitable, my lord. It's been merged with the fishery department.
Hmm.
So, my lord, proposal has been sent to the government to pay these, my lord. Not only this employee, my lord.
now tell us who will pay this interest?
Government has to pay, my lord, because there is delay on their part.
So this is public exchequer will go.
Fish pay, my lord, knows there's a loss-making organization. Has been merged with, my lord. We may be allowed to bring it on record, my lord, with the affidavit. The
Yes, you are not entitled for pension.
Let them highlight.
They say that you are not entitled for any determination in the writ petition that you are entitled for pension.
there was no revenue.
They have brought data account.
No, no, no. My lord, he has, this person has signed, my lord.
Form of amount.
This person is signed. And it was most of the amount was, my lord, released before he came to court, my lord.
According to you, what are the duties?
But well,
To file an affidavit?
I will file it.
Uh, the Gogoi and counsel hearing for the respondent number
One,
1 submits that pursuant to this court's order dated 6/9/2021 passed in WPC 5925/2019 has already been made according to speaking order dated 19th of May 2023. It's passed. Mr. Gogoi submits that he may be granted 2 weeks time to bring on record the aforesaid speaking order and details of entitlement of the petitioner and the amount that has already been paid, the details of amount due to the petitioner and the amount 8. Good. Prayer is allowed. Please this matter on. Please do after which. File an affidavit. Let us see.
The 45, my lord, also, my lord, this person has been given, my lord, 9 lakh.
Okay.
Speaking what I told.
Okay. Same order.
Same. Always.
Your Lordship, the pension proposal of the petitioner has been processed. Lord.
That was also then on 15th.
No, no. So now it is processed.
Okay.
He has to submit a certain documents. Lord, he has submitted. Now it is before the second date. Lord.
Give it. Who?
In
For
will-
petitioner. Okay. You do one thing. You give a copy to her.
Lord, I will send it.
Okay.
Soft copy.
Soft copy. Mr. Upadhyay, Learned Counsel for the respondent, submit that the pension proposal of the petitioner is at final stage, and by a communication dated 12th of February 2024, the Chief Engineer, Irrigation Department,
To the secretary. Lord. Okay.
has submitted the necessary documents, and therefore it may take another
4 weeks time.
4 weeks time
Sure.
to complete the process. In view of the aforesaid development, Mr. N. Upadhyay, Learned Counsel for the respondent, submits that matter may be adjourned for next month.
Sure.
As the some progress has been made, the prayer of adjournment stands allowed. Please this matter after weeks. On the next date of listing, Mr. Upadhyay apprised this court
Lord.
regarding the up-to-date status
Sure.
of compliance of the order in question as well as payment of pension.
All right.
A copy, give a copy will not order.
I have given a copy.
Yes, Mr. Sharma.
Application, my lord, for the order for an interim order, my lord. Whatever, my lord, here the petitioner was 40% disabled,
Mm.
physically lower part of her limb are inactive. Was appointed, my lord, on 2015 as community organizer in the Hyderabad Municipal Board.
Mm.
She was terminated while she was in leave, my lord, for ailment, and her son is also 70% disabled.
Mm.
Thereafter, after her termination, my lord, there was an interim order by the court
Mm.
in the main petition. An application for interim order filed, my lord, however, order was passed in the main petition. And
So you challenge your termination.
yeah, that is there. Their main petition is pending. In the meantime, my lord, in 2021, they issued one advertisement.
Mm.
Against that, we can came again, and this court passed the interim order.
Past
And,
an interim order where? Where is the order?
my lord, WBC, my lord, 19 to 2021.
19 to
2021. There is extended from time to time. And they were also asked to produce the records.
19 to 19 to or 19 11 1.
Two,
19 to
Yes.
21 5 4 19 to. Okay.
not to fill up the post.
Okay, then
Now, my lord, again, they have issued another press advertisement, my lord, while that is pending, my lord, on 3/1/2024, my lord, which I have annexed.
Who is representing the respondent?
My lord, I am.
Have the instruction why?
My lord,
There is
these
a
are,
clear stay.
these are contractual posts, my lord. The tenure is over, my lord. So once the tenure is over, my lord, we have to go for a fresh.
But the termination remains.
My lord,
Without inquiry, my lord,
No,
terminate.
problem is please seek a vacuum see Mr. Thor.
my lord,
That you may be correct on that. But what is the interim order?
My-
Interim order says the post of community organizer vacated by the petitioner shall not be filled up. Court is well aware that it has been vacated, terminated, but till then court has passed an order not to fill up. And that was done subsequent to an advertisement. So therefore, you file a modification order, order of modification, then you proceed or take a leave. Let's see, this is our problem, this is our. Here is some procedure. So have an instruction. At 2. When is the last date?
That is, it was, my lord.
This is the difficulty. You may be right. That the contractual right is gone, but court has passed an order where it says not to fill up that post she has
I understand,
vacated.
I understand.
Isn't it?
Yes, my
So
lord.
instruct your client not to do anything and we can decide the entire matter.
My lord, it is already due. 2020,
No. Anybody has been, you have filed an IA. Is not it?
non is that, but my lord, we also give the legal notice, my lord.
Then what is the present status of that selection?
No selection, no selection.
Mr. Dhar, we are taking this matter at 2.
My
Just
lord, if we go by the advertisement,
Hmm.
the six serial number, the six, page number 8 of the IA,
IA.
my
Yes.
lord. Serial number 6, the applicant is to be submitted.
Space, space.
Page
Yes,
number 8, my lord.
8, man.
8, my lord, and it's up.
Hmm.
My lord, from top, my lord, serial number 6,
Space, serial number 6.
the applicant is submitted on
11 January
11
24 was the last date.
24.
So therefore you have an instruction what is the present status at 2. Okay. You go through that order, specific 9 order. Just go through in the record. And there is this clear direction not to fill up that post which has been vacated. So meaning thereby, if that is the post, you cannot. If you say no, there are 2 posts, we will proceed. We'll clarify, we'll make a record your statement.
Or one more thing, my lord, they were asked to produce a record, my lord, by your document that is 6/6/22.
So we'll have everything, we'll have it. But
So
don't
they can
create a
follow
third
the
party
next
right
level.
at this moment. Specific direction.
If Mr. Dhar produces the record by next week, it can be disposed of. Short matter.
Mr. Dhar, I know you understand
I know
our anxiety. So you have an instruction today.
that instruction, my lord.
Instruction you have intimate that they should not proceed. We are fixing this matter. Or do you ask to pass an interim order?
Let me get the instruction.
You have at 2 we are taking this.
Then only my lord decide.
Yes. You at 2 we are taking. If you give an understanding, no, we will not proceed this.
No, my lord.
You
Let me get the
advise
instruction.
that. We will
Let
decide
me
it.
get the instruction. Yet to my will decide.
Yes.
After the
Yes.
I think,
Yes.
right last order, they pay 50. And it is not record the original.
Okay. So now we'll accept the services. Anybody appears?
My lord, I am for the APD still.
And any private respondents? No. When it was published, Mr.
My lord, it was published on
20,
18th of January 2020.
okay. In compliance of this court's order dated 20/12/2022, an affidavit has been filed along with the original copy of the newspaper. The newspaper, comma, reflecting notice to paper publication upon the private respondent. Upon the selected candidate. Full stop. Peruse the affidavit as well as Xerox copy of the, as well as original copy of the newspaper. Full stop. The notice upon the selected candidate, namely respondent number,
My lord, they will be from 40 to
respondent number but they have not been incorporated.
they were not made parties. Right? It's
14 to 30.
But without implement. Where is that order?
2012. 2012.
Anything survive? What is that direction?
My lord, Dr. Pitt kindly come to fourth paragraph. The petitioner is directed to take steps by way of the purpose of
Where? The prisoner is directed.
the petitioner not direct
Have you intimated?
That I have taken. It was a highly contested matter, my lord. Mr. UK Nair was handling this matter.
On that. Don't take UPN as name.
No, he was engaged.
Forget about it.
Now we have to make fresh arrangement.
Do whatever you like. It. Now UPN's claim is gone. Up to 2 weeks we can accept. Up to a month we can accept. Not now. That's fine. In terms of people. Not a selected candidate. You need to do a formality. Think over it. They are not. Ought to have been implemented then notice. Paper published.
they publish the result. Aware.
No, that's
Now
fine.
we
No,
are
no,
aware
we are
that-
not saying that.
Now,
Okay, anyway, we are not expressing anything as on that. Mr. Gogoi, learned counsel for the petitioner, for the respondent APTCL, press for and is granted
2 weeks. 3 weeks.
week. It's a long period, 2 weeks to file an affidavit as directed by this court under its order dated 2012-2020. Okay?
Mark.
Then let us see if that is served. If they come, it's
my lord, what attempt it is order
one.
the affidavit starts at 144.
Okay, if that is there, then we need not fight.
I don't care for respond number 20. Starts at 144.
140. Okay.
And will
Comma,
kindly come
an
to
affidavit,
para 6.
an affidavit has already filed by the respondent number on behalf by respondent number
Twen-
2 and 3 in terms of this court's order dated 2012-2022. offer relating putting the selected candidate under notice as regards pendency of the present.
Paragraph
Uh,
page 159.
However, there was the same. It is seen that the selected candidates were put on notice by way of the affidavit by the employer in terms of this court's order dated 2012-2022, and the petitioner has also published the paper has also made paper publication as regards pendency of the present petition. However, none appear for the aforesaid persons, though they are not yet implicated as parties. In that view of the matter, let this court await for 3 weeks for proceeding further. Please this matter. Let us see if anybody. If not, then we'll see. That could have solved this problem after implementation. Now they will come. Why should we go? We are not a party. Isn't it?
Yes,
But that is the
even they here also, when this is the first objection will come. Alright.
some of the parties, expert proposed, the
Okay, we'll see that on the next step. If large number of candidates, they may come also that yeah, my appointment is under stake. Let us party. That may be one way of looking at it. Let us see. Yes, Saliha, anything?
Yes, my lord. Here, lordship, here a communication has been sent regarding the arrears salary to the government. Lord. I have just received the letter today, lordship. I can just inquire as to the position of the this proposal that has been sent to the government.
Pursuant to this court's order dated 12/2/2024, Mr. A. Saliha, Learned Counsel, on behalf of the respondent,
Number 3.
number 3, submits that on instruction submits that already the additional chief medical and health officer within bracket FW Borpeta has prepared arrears of salary statement as regards payment of 9% interest, and same is under process. Accordingly, he submits that prayer may be allowed, adjournment may be granted for 4 weeks. And he will apprise this court regarding the present status of the payment of interest as directed by this court under its order dated 15/11/2018 in WPC
1526
1526 2015. Equal to Director of has already prepared a salary statement. Revenue. It's a handy. The petitioners were directed, you were directed, the petitioners were directed to file a representation. They are claiming benefit under the determination made by this court in Kobiram Rajbanshi as well as Naumon Kolita. Okay. So they were directed to file a representation, and you were directed to consider and pass a statement. Now this matter is pending since 2018. You want to know? at 2. Have a telephonic instruction, give a copy. Okay, I think this has been complied.
I can.
They are also not having any
That will
contact with
Mr.
that.
Earlier.
Is that it?
Not-
They are also not having. Might have pension granted. Otherwise, they would have come to challenge that it should not be kept in. Okay, you give her at 2.
Lordship.
I did, but
Yes, 9 and 12, they are under your employment.
We'll give notice, man.
Okay. The Learned Counsel for the petitioner submits that though a direction has been issued by the Lajima Court on 29/9/2023 to take steps upon respondent number 9 and 2 by registered post with AD within 7 days from the aforesaid order, comma. However, comma, such steps could not be taken up for want of detailed addresses of the respondent numbers 9 and 12. Full stop. He further submits that the respondent number 9 and 12 has already been selected and appointed and now serving under respondent APDCL. And therefore, the respondent APDCL may give the detailed address of the respondent number 9 and 12 so as to enable the petitioner to take appropriate steps. Full stop. Mr. Gogoi, Learned Counsel for the respondent APDCL, submits that he can obtain the instruction of respondent, obtain the detailed address of respondent number 9 and 10 as present place of posting of the respondent number 9 and 12 and can furnish it to the Learned Counsel.
I'll furnish.
However, he will require 10 days time. Okay. Accordingly, matter stands adjourned and be listed after 4 weeks. In the meantime, Mr. Gogoi shall furnish the address of respondent number 9 and 12 to the Learned Counsel for the petitioner, and thereafter the petitioner shall take step for issuance of notice upon the said respondent number 9 and 12 in terms of the Lajima Court's order dated 9/9/2023. Please take.
This matter, the present principal secretary to the government of Assam.
Hmm.
That-
Hmm.
And we got our client
You have not?
got two from our
Lordship, here, let the I can give them the name of the officer who is actually looking after. In the meantime, copy may be also provided. I can look.
It's simple. I think you have complied here.
Yes, Lordship,
Because here are two parts that I have put an ANM.
yes, Lord.
Their first prayer was that our case should be controlled. Court rejected. Second prayer was that our case should be regularized.
Yep.
Court says, okay, you go, we are relegating you.
Representation.
Represented. That is was to be disposed of. I do not think that that has not been
Yes,
disposed.
Lordship, I can get a copy of the petition.
Give
I
a
can-
copy.
and-
Okay. This court under its the present contempt petition is filed alleging willful and deliberate violation of this court's order dated 17/11/2020 passed in WPC 4757 of 2020. Full stop. By the aforesaid order, by the aforesaid order, the petitioners were allowed to claim, allowed to file representation in support, allowed to file representation before the principal secretary to the government of Assam, Health and Family Welfare Department for their claim of regularization of services of their long contractual services as auxiliary nurse and midwife. And it was further provided in the said order that in the event such representation is made, same be considered and disposed of strictly in accordance with law within an outer limit of period of 8 weeks from the date of receipt of such representation. Full stop. It is submitted that the petitioner has already filed representation, but said representation has not yet been. Full stop. It is further submitted by learned counsel for the petitioner that the present respondent, sole respondent,
Yes,
sole
sole.
respondent or respond there are other
Sole
respondent.
respondent, Lord.
The the sole respondent has in the meantime been transferred out of the post transferred out and a new incumbent has joined. However, the petitioner has not taken any steps. However, the learned counsel for the petitioner submits that they could not take any steps to implement the new incumbent as they are not having any connection with their clients. Full stop. Be that as it may, this court has requested Mr. Saliha, learned counsel to obtain whether the representation filed by the petitioner has in the meantime. Mr. Saliha submits that he will obtain such instruction and apprise this court on the next day.
2 weeks, Lord.
Full stop. Please this matter after 2 weeks. In the meantime, the learned counsel for the petitioner shall furnish 2 copies of the contempt petition for Mr. Saliha. List accordingly. Registry to list this matter showing name of Mr. A. Saliha.
Lord.
May I please, Lord, as per direction of this court, Lord, the order record has not come, Lord. Order week time, Lord. 1 week time, Lord.
Last 8 years. No affidavit been filed.
Record has come from the Chief Court.
Now again they are
What is matter about?
upon relating to appointment of Anganwadi worker.
Election-
Added on the petition. You could find the annexure 1, my lord, election letter, my lord.
Election was made, Lord. Subsequently, it was cancelled.
My lord, you could find to inform that you have stated many Anganwadi worker in the Anganwadi center of Wednesday, section 6 by child welfare project on the tender voluntary service. You will find the next page, my lord. With regard
Yes,
to
that matter.
There
Now I
was a-
recall. Yes,
on the basis of
have it.
public meeting,
When? Monday? Next Monday?
Huh?
Huh?
No.
Yes,
Letter
you
has
want to say
communicated,
something?
Letter has sent, Lord.
Huh?
Letter has been sent, Lord.
You have a, nowadays not
sir,
the
no.
days of letter.
Lord,
yeah,
Lord,
You send
on
now
Monday, Lord.
letters to your friends,
Monday,
You-
next month.
to your parents.
Next Monday, Lord.
These are not days of letters. These are days of WhatsApp, Telegram. Don't say that we have sent a letter.
Hmm.
Mails.
Mail has been sent, Lord.
Okay, then we'll take action.
On Monday, Lord. On Monday.
Uh,
On Monday.
The learned state council has submitted that pursuant to this court order dated 12/2/2024, though the record has been requisitioned, but he has not yet received such record. However, he submits that he may be granted time till next Monday to produce such record. This matter is pending since 2016.
16.
He that as a last chance, the petitioner, the respondents are granted to produce the record in terms of this court order dated 12/2/2024.
Problem.
Or 28, not 26. 27th or 20?
Not 27.
20.
Happy, sir.
Yes.
Well, in this case, my lord, in 1994, the petitioner was appointed, my lord, as junior instructor of law in
Junior?
ITI Tribunal. My lord,
Huh?
on ad hoc basis.
Hmm.
My lord, declaration of their services sorting.
Marat, we have filed our affidavit. Let him ask Marat whether he is going to keep a reply or not.
My
Lordship
lord,
may fix the
I
case for hearing, my lord.
respond 3 and 4. It only one paragraph, my lord, I have to take instruction,
Okay.
lordship. But, other as regards salary for a particular period of time. But as regards the regulation, my lord, nothing has set my deputy lordship. The specific orders of the honorable court, my lord, to
Who is preparing for the private respondent?
But they have not appeared.
Not here.
Now, there are phone numbers of phone.
Hmm.
No problem. Lordship may direct him to file a reply, my lord. That's not a lesson.
No, why should we direct?
But if he
Then
did not
yes, my lord,
declare to
take
file the
instruction, my lord,
reply,
I
my
have
lord,
no
then my lord,
communication with
Lordship
my
may
lord.
fix this case for hearing, my lord.
We'll hear what are you doing? We are hearing it.
Usual course of hearing, my lord.
Huh?
There is no urgency in this case, my lord.
Urgency is here.
Why,
is why I'm
why
supposed-
should we fix it for usual cause? That leave up to us. Isn't it?
My humble submission.
You say that I have difficulty. Then we'll
No,
adjourn.
I don't want.
Yes, no
I am
problem.
ready, my lord.
If he's not saying he will not file affidavit or not,
then
we'll
I am ready.
proceed.
My lord, as regards my lord, the salary that
Hmm.
means lordship, I have to take that of that.
Let him take instruction.
Lord, that may be fixed lordship. I know it's not the part. It's a matter of regulation, my lord. The respondents are thinking about the matter.
What is your, where is the selection process for appointment,
My lord,
regularization?
process on my lord, edit card, one letter was there, lordship. Admit card kindly see, lordship, that is lordship address 23 kindly see.
Yes.
23. Like 2 times I appeared in the my lord selection process, lordship. I participated, lordship. It is the first time no finalization was there. Second time again process was initiated, my lord. The call letter kindly see page 20. This is a admit card, not call letter.
What is the decision?
Decision, lordship. Next page is the my lord the appointment. Just direct appointment to the my lord to one Ashrafuddin Lashkar. Next page 24. My lord, in admit card kindly see my rule number. SRI E69.
Any advertisement regarding regularization?
Their process was there, my lord. Written test was there.
Where is the select list?
Select list, my lord. This is the select list. Next page, my lord.
Page,
Direct appointment letters are there.
Page.
Page 25, this is the, my lord, original, but 11 portion is page 24. I have typed again, lord. 24 is the type copy, lordship, subject to termination. Subject to termination of service without notice and without assigning any return thereof, the following persons are hereby appointed temporarily as junior instructor. Now, my lord, the serial number 4 is Ashrafuddin Lashkar. The my lord, roll number kindly see, lord. This is my roll number.
What is their reply in this regard?
Nothing, Lord.
Okay.
Saying that,
My lord, we have priority.
Okay, when are you will be ready?
Lord, 1 week, I updated the part.
Okay, learned counsel for the petitioner submits that he may be granted 10 days time to obtain instruction whether the petitioner shall file any reply to the affidavit in opposition filed by the respondent, respondents, official respondent,
That's one of 3 and 4.
respondent number 3 and 4, and to file affidavit if so. Affidavit, reply affidavit if so. Prayer is allowed, please this method up.
Right.
Does be possible ready with the how you have proceeded record? Okay.
Let the lordship record one line.
Okay,
Hold the record.
the basic challenge is this repetition is that do after a selection process for regulation of service of the petitioner and similarly situated person, comma, the petitioner was selected. However, against his roll number, the respondent number,
He is not respondent, Lordship. Asrapuddin, Lordship. I have not challenged him. He's way back in 1990.
but some other another person was regularized. Full stop. Full stop. It is the case of the petitioner that he has wrongly been deprived of regulation and he is still continuing in his service without the benefit of regularization in terms of this court's earlier interim order. Full stop. The respondents have filed an affidavit. However, the record of selection in the considered opinion may be necessary for determining the real controversy. Accordingly, the task shall be ready with the selection record for regulation. A selection record in question for regulation of the petitioner and the other persons. List record. Need to do that.
All right.
But matter, we have some structure, authorized not structure.
Hmm.
But practice some time.
What was the prayer?
Lordship, it was for earlier salary of the Anganwadi worker.
Hmm. Now, according to you, she has got the salary.
Probably has got it, but we do not think that
The learned counsel for the petitioner submits that she will obtain exact instruction whether the salary arrears of salary claim for has already been paid and this matter has become whether this matter has become has already been paid. What is the affidavit in opposition filed? Oh, if DRNC is not entitled, then how can we decide? It's not infractions, we'll decide on merit.
That period,
that so that it gets decided on output. What I was instructed that she may have.
If they are saying no, you are not entitled, how can we decide? If you know, okay, we'll have it. If they say you are not entitled, until and unless you can show some material which is not controversial, disputed. Of course, if you can show that no, this is just there. But if they dispute that you are not. Anyway. 2 weeks, madam. Yes, Mr. Sharma.
Actually, for exact product paper, because I actually the instruct after the instruct I put the data perspective. Sometime next week time.
Otherwise, it is infracted.
Why?
They expand their force, Lordship. The DLC recommended 2017, Lordship. After that, Lordship, it was pending, Lordship.
Not considered by LCS.
In the principle 10 of this,
Any decision by SLC?
no, Lordship, in the OM, Lordship, principle 10, it is clearly
Oh, but there
stated,
should be
Lordship.
some decision by the way. We are not SLC here. We cannot decide.
No, Lordship, as per the principle of this OM, Lordship.
No, as there are many principles. So then there is no necessity of SLC. Who will apply this? Their mind that this principle is applicable or not? Who? We.
No.
If the SLC will have to take, if it is a recommended to SLC have to give a reason. Or can they say principle is already settled, will not pass anyone? Is it?
It is pending, Lordship.
So how can you keep it pending and
It will be
tomorrow
a-
you will say,
2 years,
then
the principle, then it is.
cannot have.
Hello.
Mr. K.D. Sharma, learned counsel for the press court and is granted weeks time to obtain instruction regarding the present press for 2 weeks time. Don't consider.
Obliged.
You have the instruction. Your case might have been either accepted or rejected.
Definitely.
No, that you will take adjournment. Why should you take that?
This is a my lord corporation appointment 2005. It was twice.
She is not keeping well. She is not here. That's why we are not asking any of her.
After
It is submitted that Ms. K. Devi, learned counsel for a petitioner, is not well and undergoing treatment. If you have that matter says adjourned and is delisted after 4. Yes.
It's all. One. मतलब तो कितना है चाहिए कितना नहीं चाहिए 1030
Hmm. You don't want to be get caught. You have been appointed.
Appointed Lordship after 70. In a
That's your appointment.
book post,
Your appointment should go.
but Lordship, my question is that if the respondent have to appoint me in a book post, then why they not appoint me in a year 24
Tell us,
5?
where is your right to get appointment under a gate? We'll hear this matter. Are you still working? Grade 4?
Yes, Lordship,
Or you have given it up that I will not work for grade 4? Are you working as grade 4?
because Lordship,
No, not the answer the question. Are you working as grade 4?
I'm working in grade 4.
Okay, you work for
But
some time.
Lordship,
Can
my
we call for the record to notice, please, this matter for hearing. Don't waste time on this. Yes. Why?
So I
Okay, it is submitted that Arvind Council, Mr. P.K. Das is not keeping well according to April on behalf of the and on behalf of him. There is a list of attributes.
keep your
Hey, Mr.
Yes, Mr. Sharma.
This respondent bank has submitted the affidavit to position Lordship.
Okay.
Petitioner is going to file affidavit in dialogue.
Okay.
Lordship, may I pray for
Okay. Pursuant to this court order dated 23/8/2023, an affidavit has been filed on 27/9/2023. Mr. R. Sharma, Learned Counsel for the petitioner, press has Sharma, press for and is granted 4 weeks time to file a reply affidavit. Huh? So I am affidavit. Yes, Gogoi. What is this?
Regarding Lordship, that unlucky bin matter, Lordship.
Oh,
My brother is not here.
okay. None appears for the petition. Just we want to understand that what is
Lordship,
however, though Mr. Gogoi K. Gogoi, Learned Counsel for the Education, Learned CGSC, and Mr. M. Hussain for the respondent number 4 and 5 are present. List this matter. However, in the interest of justice, matter stands adjourned and list after fixed. Just we want to understand what is the procedure. That's all. Yes, Mr. Deka.
may please, Lord. Lord, pertains to the compassionate appointment. The petitioner's husband was a permanent employee of the FBDCL, who died in harness on 36 2016. Thereafter, they made an application for compassionate appointment on 8/8/2016. That was duly forwarded. Document verification was also done. Thereafter, on allowed to get the impugn order at page 45 on 14/9/2021. This impugn order was issued. May I read from the starting matter.
We have filed affidavit. Considered and rejected.
Let me submit.
When your husband died?
My lord, on 36/2016.
36/20. Okay. How he died?
Died in illness. It's covered, my lord.
Hmm.
What my lord wants to point out, I understand, it covers under the scheme.
Okay.
Because my lord will get a para free, whereas as per FPTCL compassionate appointment scheme,
Hmm.
2014,
Hmm.
effective 18 to 2014 to 31/3/2017.
Earlier was effective.
It was a 2005 scheme, my lord.
Where is that?
My lord will get at the prior paragraph, second paragraph, at page 45, my lord. Appointment on compassionate ground in FPTCL was made under scheme of 2005 and FPTCL compassionate appointment scheme 2014. As per the scheme introduced on 30/4/2005, that is the 2005
Okay,
scheme.
that is 5. Okay, what about the 4?
2014, my lord. 2014 was later on. Whereas as per FPTCL compassionate appointment scheme 2014, effective.
So they have removed this portion.
Yes, they have removed this portion.
So that specific during extremis and course of
no,
that has gone under 2014.
Yes.
Okay.
So as I was entitled, so I made an application. Therefore, my lord will directly come to the last paragraph with.
No, where is their affidavit? How they have compared all these 16%?
Yes, how they have dealt with, my lord.
Yes.
They have, my lord will get a para 5.
Page 57.
Para 5. Their affidavit at para 5, my lord. Page 3. As I am getting family pension, that was the main ground for rejection.
Where is your rejection?
My lord will get at para 5, my lord. Their affidavit.
No. In the committee.
My lord, in the impugn order,
Last page,
Annexure A.
annexure, last page of that next column number 17.
yes. But who has issued it, my lord? There is no mention. It's nothing but a paper. It's mere paper. Who has issued it, from where they have extracted it? Nothing.
Yes, Gogoi, from where have you extracted this? Any statement regarding, what is the statement regarding Annex RA?
My lord, at paragraph 8, my lord, we consider total 136 numbers of applications, out of which 121 rejected, 15 were, we consider, so we received my lord, 136,
No,
out of which
so as the, we do, prima facie do not subject to what you argued, may be reasonable, but how do you, if this is an afterthought or this is a part of any analysis of your selection or of your committee?
my lord, please.
There is nothing or not, no,
Yes, my
nothing is written.
Somebody has filed this. Today I am on the receiving end.
He has rightly pointed out. This is, how can we believe on this until this is authenticated
There
by
is
someone?
there has to be some environmental.
That in the affidavit that from the selection committee minus, this has been extracted.
I have to stick
Okay.
instructions.
So, the present requisition is filed assailing the decision, assailing an order dated
My lord, 14/9/2021.
14/9/2021, whereby the claim of the petitioner for compassionate appointment has been rejected. However, the aforesaid order so far relating the reason of rejection of the case of the petitioner is not reflected. An affidavit has been filed by the respondent APDCL, wherein a document within bracket annexer 1, a document annexer 1 is annexed.
Annexer A, my lord.
Annexer A is annexed to show the decision of the selection committee in the column within inverted comma remarks of the selection committee. However, affidavit is silent as regard the source of such remark,
Source or author, my lord,
or
nothing.
source or slash or author of such record, such annexer. Full stop. At this stage, Mr. Gogoi, learned counsel for the APDCL, submits that he may be allowed to produce the selection record on the basis of which the annexer A was prepared. Full stop. Prayer is allowed. Accordingly, place this matter on 28th of March 2020.
My lord, can it be 29?
20.
Or 20?
28th of March 2024. In the meantime, the petitioner may file a reply affidavit to the affidavit in opposition filed by the petitioner, if so.
Not of my lord.
You have that. You have that.
Yes.
How you have
Yes.
this is some from something.
Yes.
On the basis of something somebody has prepared it.
Yes.
At least
This doesn't contain anything. Who wrote it?
Not of it.
yes, fella. Mr. Gogoi, there was a last order. Some translated NPR report was
Lord, I have received it.
you have received.
I have received it.
Now, what is the issue here, madam? Are you ready? Yes.
He kept the script. He took it from 1910, 19 to 1712, 19. Due to his mother death, then after after this, he faced his depression. recovery, he reported back to his duty in Jharkhand in the month of September 2020.
Yes.
But one impute order was passed, dated 12/4/2021, by the Commission of 11 Battalion CRPF, and the impute order was not
In,
served.
impugn, what was the impugn order?
It was not served.
You are not aware.
After the RTI, he was given the
What was the final outcome of that impugn order? Where is that impugn order? Impugn order, page?
translated copy of the impute order, page number 29.
Lordship, he also filed appeal against the order. Lordship.
Depending.
Appeal was rejected. And after
But he appeared
he
subsequently.
appeared.
He appeared,
He
and
appeared in
you have cancelled warrant. You have asked him to sans.
He even participated the DP also, Lordship,
Yeah.
but he pleaded guilty and he is not replied. Even inquiry report also submitted. Everything was submitted. All procedure was followed. Record is there. Lordship.
He filed reply also.
Lordship.
He filed reply also.
No.
But
Against,
he appeared.
he appeared, Lordship. He like against the inquiry report also given three times chances to file Lordship reply. Lordship. He himself submitted a statement before the presenting officer. Lordship. Everything is there, Lordship.
are your grounds of challenge, madam?
He was in with lots of medical right
But you went there.
yes,
You went there.
yes, in the year of 20, but after the joining the order
Is it item number?
20,
Oh, let us see the report.
I thought of the record and date of event also there. So the record, most part is Hindi Lordship.
Anyway,
The date of event is there Lordship. On the very first day to Lordship, passing of the Lordship. Okay, Lordship.
yes, madam, tell your ground. But when you went there, then you were out of depression. You said that I have done everything, I plead guilty. What can we do?
in
Then thereafter he participated in the process. He was asked to have defense assistant. He said no, no. He was asked to have. We cannot go behind the record.
the order was in 20,
No, no. Yes, but is it Mr. Kokot?
Sitting was started on 11th. He was participated from 11, 12, 20 Lordship.
He was absent from 8-1. His leave was up to 17, 12,
29.
2019.
Yes.
19. Is that it?
Yes.
Then on 18, when he was supposed to join on 17, 12,
Yes.
he did not join till 2/12/2020.
Okay.
Okay. Then notices were issued, warrants were issued. Then on 3/12/20, you reported in the unit. So from
Almost
From-
1 year. What?
you were supposed to join on 17/12/19. You joined on 2/3/12, reported, not joined, report on 3/12/2020, at least after 1 year, almost 1 year.
Almost 1 year.
Then the warrant of arrest issued against you recalled. You were declared deserter, were recalled.
On 11/12.
Deserter was recalled. Then preliminary hearing started. And you said that I have received all the, according to record, I have received all the communications issued to me. Then you were asked to whether you plead guilty or not. Then you said I plead guilty. Then thereafter, even after you pleaded guilty, they proceeded with the witnesses. You denied to, you were in the unit at that point of time. You denied to cross-examine. Now what can we decide now? You were not, you were well at that point of time.
Even after Lordship handing over that charges, he also plead guilty.
Thereafter again charge were given, again inquiry report was given. What to do? Dismiss. Then satisfy us. These are the parameters of departmental proceeding. This is the power of writ court, and this is under these circumstances we should interfere. This is the wrong they have committed.
Then he was unable to think about all the
Who will decide that? But you have joined there. How can we believe that? You have not gone with any your family member to say that he is ill, so give some time. This is the medical report. Nothing of that sort. All medical reports you are annexed with the writ petition. We are with you. Can we have a
family member
understand? But he went alone. Meaning thereby what?
putting him with all
Who forced you? 1 year they could not take you back. You were not even arrested. They recalled your warrant. These are the records. In a writ court, we cannot go beyond the record until and unless you can show this is a perversion. From where do you know that this
That
is
was declared in T4/24.
Huh?
For appeal, he was declared. After that also, he was not arrested up to 12th of December.
Subsequently, he reported in the.
Lordship,
It's
then,
not that he was arrested.
Lordship, then,
So warrant itself was recalled.
recall, Lord.
Since you are there.
Lordship.
You want to get it dismissed at your hand or your senior's hand? Then why have you wasted time? You said you are ready. That's why I asked you the question. Are you ready? You said I am ready. When? You cannot wait for him. What is the power of a High Court under Article 226 in case of a departmental proceeding? And whether we can exercise this power in the given text of the present. That's all. We cannot sit as an appellate authority. Mr. Deuri, all persons from Pathshalas are having this problem or what? Home sweet home. Huh? Seems. And they become wise when they meet Deuri and Mr. I. Chaudhary. Isn't it? They are mistaken in life that they have not met you earlier. Isn't it? Moment you become met I. Chaudhary, he has become wise. What to do? But you will have to argue on that day. Come prepared. Come prepared that these are the, you will have to address us what this court is having, what kind of power of judicial review. Under what circumstances we can interfere this principle of law, and then we will have to show us that these principles are applicable in this case because of this reason. This is a violation of principles of natural justice. This is perversity. This is the procedural lacuna that they ought to have done this. They have not done it. What? We did that. The prayer of the learned council. Now, in terms of this court's order dated 21/7/2023, Mr. K. Gogoi, Ernest CGSC, has produced and translated copy of the entire report. Same is kept on record. You want a copy?
Lordship may keep.
Then it's kept. Learned counsel for the petitioner. Copy that she may be granted some time to argue. There is allowed with this matter. 13.
Record, I think it.
Record copy. Mr. Gogoi has also produced record. Record be kept with Mr. Gogoi. Till the next day. But Mr. Gogoi, CISF is smarter than you. They have ensured that notices were received. They have not gone to the register post. They sent the officer in charge of the local police station. He reported, then he sent a letter and both were exhibited. What can we do?
Lordship, they have.
Yes, they have properly, the police officer reported, those signatures of the petitioners were there, those were exhibited. So those are there, that service of notice to register post. Let us see. We'll see on the next. What is this, Mr. Gogoi?
These are some left out casual workers. This is second round litigation matter. After Uma Devi matter, the exercise and Upendra's exercise was carried out by the department, giving benefits of Uma Devi to casual workers. There was a certain parameters laid down. They failed to meet those and they were not considered. The first round of litigation matter they came. It was disposed to pass a speaking order on merit. And
Where is
then-
the speaker to page 62?
Yes, page 60.
Who is for the petitioner?
Some Mr. Kumar was
B. Kumar.
MPN
This is Forest.
Forest. 63 see there was a inventory there's some pro forma has to be filled up and some record they has to satisfy those criteria. The petition whispers nothing about that. They're saying that such rejection is arbitrary.
What is account number, sir? And
But they want to show that
Hmm.
they had worked as casual workers
Hmm.
beyond 10 years, man.
how do they are proposing to show that account first page of account number?
They want to show, they want to indicate and display and demonstrate that they had been working with the department for 10 years.
No,
and
there must be some transaction. Those are not there.
that is not them. Only account number names are there.
Account, what to account number 2? They will have, they can show that wrongly rejected. I have this material. Then also we can think of sending that you verify their record.
Hmm.
None appears for the petitioner on call. So Mr. Gogoi, Learned P. Gogoi, Learned Counsel for the forest is present. However, in the interest of the matter, I don't have to list
Always.
Yes,
My lord, in this case, I am for the account number 4, my lord. In the petitioner, my lord, they did not meet us any party, my lord. I filed one I, my lord, for implementation of us, my lord.
what is the issue here?
Issue is regarding, my lord, my appointment to the post of Anganwadi worker, my lord, in a concerned center. I was lawfully appointed, my lord. In my lord, one of my IA, my lord, for vacating the interim order, my lord, I filed, that is, my lord, IA number
None
126.
appears for the petitioner on call. None did represent the petitioner when the matter was called on 24th and 2023. Accordingly, the writ petition stands dismissed for non-prosecution. Interim order passed earlier.
That was already vacated.
Okay, if any, then
I love it.
Huh?
Please suppress material. I was lawfully appointed. I have been discharging my duty since long time.
Okay.
I love it.
This is my lord. The statement issue of the post of administrative assistant.
Hmm.
We applied for that.
Hmm.
Putting our testimonial along with all other candidates for sent to the government. Now, my lord, the government has written a letter, the deputy commissioner again, that my lord will find it page 80. But basically, my lord, there is that letter because in the earlier round of selection which took place in 2010, my for the same post, the government has considered our case. We came in the zone of consideration, but my lord, overall we are not considered. But other candidate was appointed as the administrative officer in the office of the deputy commissioner. But this time, my lord, they taken another view. So the very department
No, what the rule says?
rule says, my lord, 15 years experience in the office of the deputy commissioner.
No. They say their ground, according to them, their ground is that the post of administrative officer
Yes.
is not under the purview of Assam Ministry District Establishment
No, it's 2009. It has been amended.
1967.
Yes, it has been amended in 2009.
Let's just listen to it.
Yes.
1967. So it was amended in 2009, and this was outside the purview of your purview of the promotion. Now, so accordingly, they have passed an order saying that you cannot now fill up.
Right.
No, you say that the impugned letter 6/12/2021.
12.
2021.
Yes, my.
Is that it?
He said, my you observed that the incumbent Bimal Bodgoy, stenographer,
Where is the impugned order? Page?
page 86.
Who is for the general GAD?
My lord, Mr. B. Gogoi appears.
But by there I can find my there going to be but
I'm appearing for account number 3, my lord.
Where is the impugned?
Page 86.
Next. Para 4 months. Page 1.
Okay, they say that a stenographer is not, you are not a, feeder cadre
Yes,
or
but we
promotion.
are the junior assistant, my lord. The quotation list is there. I'll show your lordship.
Okay,
We are the junior.
well, yes, Mr. Gogoi, learned, counsel,
Yes.
appearing, G. Gogoi, learned,
One, respondent, one.
learned standing counsel for general admission department. JD,
Yes.
GAD, submits that he will be able to file the affidavit by within a period of 10 days. Accordingly, he seeks for an adjournment. Prayer is allowed. Please this matter. Give a date after quick. 15th of March. 24.
Interim.
Okay, interim order pass earlier. Shall continue.
Okay.
The petitioner has been discharged the role of a Gaupura since 2005 in Piragaon, Moja, Kolasbari Reputation. And there was an advertisement for filling up all the vacant posts of Gaupura that is circle of it. Thereby bringing in the post of the petitioner also under that advertisement for to fill up newly. The petitioner contends here that he submitted earlier he submitted a PAN card which had shown a wrong birth date. And then he rectified also the same I have annexed here. But they did not correct that and they put this post also advertised as shown to be which they had put for the question. Now, Lordship, I have also there was instruction sought for Lordship, and according to my age, what I'm saying now is same as the Aadhaar and my school certificate.
So you have already been, I think there will be an order of your termination.
Yes, I have.
Huh?
No, they did not terminate me. That
In
is
terms
only-
of that rule and amended rule, in terms of the amended executive instruction, that executive instruction says that deputy commissioner issue a termination order. Is there any termination order, Mr.
Termination order is not matter. When the age 65 years has been over then they are given a notice. So you are no more. in the-
That we understand,
Sure.
but two aspects are there.
Sure.
One is you are saying her to be or him to be 65.
Sure.
So far, I recall the executive instruction itself says that the deputy commissioner is the authority to determine,
Lord,
and accordingly, deputy commissioner will do the needful. Executive instruction.
Lord.
Suppose deputy commissioner says you are 65. Okay, fine, on the basis of certain documents.
Lord,
But she says, no, your documents are wrong. Actually, my age is not 65. Okay.
Right.
Now, what will the deputy commissioner cannot be the monarch. The executive instruction itself gives him the power to determine the age. So, when a power is given, it should be exercised in the touchstone of the others right and under Article 14. Somebody may say, yes, I am not 65, you have done a mistake. So you should be given an opportunity. Okay, why are you saying it's a mistake? They will say, if you are satisfied, you are not, then you pass that, no, your claim is hereby rejected.
that is true.
If that is true, that is the order.
Even that when the petitioner was appointed, what document he has
Exactly,
given.
because
That
see,
has to be examined by
see,
the deputy.
it's basically a civil
Lord, they will
civil. Now, if it is a civil post, assuming for a moment that in stricto sensu some disciplinary service and appeal rule is not applicable, then also they require a minimum
quality.
a minimum hearing a kind when there is a dispute. So far relating to fixation of 65, that this court has negated that no, 65 they have a power, they can do it. It cannot be that you will till you are sick, that cannot be. So therefore that was upheld. If that is upheld, Now determination of process of 65 should be reasonable.
What they say that my PAN card shows my date of birth is 65.
Any affidavit file?
So they was last.
Now tell us what is under challenge here.
Lordship, my,
Any stay in the advertisement?
yes,
No.
Lord.
Huh?
Yes, there is a stay.
Okay.
Page 2, Lordship.
Okay, until further order. Okay. Where is the impugn?
Lordship. Just that. It's in under
Page 16.
yes, page 19, Lordship. Palashpat Borduar,
You are related to Birogao,
Lordship.
Borduar, Polasbari, 109.
109. Biragaon, yes.
So you are still working.
Yes, Lordship. There's nothing like that. They said that now they have put this one in advertisement. I submitted representation.
Where is the judge? I have passed an order. Till cover this and leave it here.
Lordship,
That
please.
Nagaon. Nagaon.
I don't know.
Send it back. Send it back.
Okay.
He'll decide because we cannot decide which PAN card is. What was their entry into?
On the last petition, Lordship, the counsel who appeared on behalf of the dictee, Lordship, he said that he will check it in the, but the order does not reflect that. It says that
You will
it's
check in what?
he'll check it in the income tax department, whether it's right or
Oh, that.
that
Can
is
we,
yeah.
are we sitting over
no,
who
Lordship.
this facts finding? What is
Yes.
that order?
My simple thing
You
is
are dear Mr. Dhar.
I was there. I remember the council.
Hi, where there?
I was there.
That was the only option. We
It
have
was
not
on the official sent back to the
sent back and saying that it is the why it is sent to deputy governor because the executive instruction itself gives him a power for determination. So he'll have to determine. That's all. Till then, he will not fill up the post.
Yes.
That's all.
It
That's why he's working till then. In
was-
earlier cases, there was a termination.
was-
That's right.
so
Yeah.
my termination was only on the basis of the PAN card.
Where is the termination order?
No, sorry. My post was advertised.
Why you are
Why
saying
so-
termination? Where is the
No, no,
termination?
my post was
Your
advertised.
apprehension is that I am here,
Yeah,
my
but-
seat is been taken away by advertisement. Advertisement is
yes,
still.
yes.
No further action is there,
No.
so we'll remand it back to the deputy commissioner. Give us that order. You are not aware.
This is the first step.
Huh?
Lordship, just give me a little time. Let me go to the order.
What we have done is we said that there was a termination in so far Nagaon. He had two affidavits, two PAN cards. One is having different age, other is having different age. Second was that he presented the Aadhaar card before the deputy commissioner. Then what government did is government sent him for a authentication test. Now the medical board gives a age. If we take the middle age, he is not yet 65. If we take the upper age, he is a 65. So there is not conclusive determination. So we hold that there was the age determination was not conclusive. So therefore we remanded back it to the deputy commissioner along with a liberty to the petitioner to submit anything that can, and deputy commissioner to also have other documents like school leaving certificate or school anything. So they will have a determination because the executive instruction itself says it is the deputy commissioner.
And here, it is very simple. Lordship.
No, we understand simple. What kind of order you want?
They
Tell
have
us
to-
that.
They have to do it.
So if
I-
they all have to do, we'll send
no,
it.
because what I said that when I submitted that to the income tax department, it's wrong, and they verified it.
No,
rectified
understand.
this time.
That's
the thing. That's
that we
all.
understand. You whatever you want to raise,
Raise it before the.
raise it before the deputy commissioner.
Okay.
Or you want this writ court to be converted into a
No,
appellate court of the deputy. If no, then that is the only option. Or we'll have to have some boxes here.
I understand.
That is the difficulty. Give us the order so that we can dispose it of. Who was the lawyer? Which was the date? Huh? I show the reason. Yes. Date? So I think there will be some other cases also. I thought that,
It was very specific.
so there must be some other case that will help us because we have quoted everything. What
Yes.
was the executive instruction? What was its mandate? Why the principles of national justice is required? Everything we have
So
recorded.
that's why we filed a report on that count only. That it's not like that. They should have just before the proceedings, Lordship. Instead of that, they have advertised it.
Dispose of
My lord, the main problem is here, my lord, that the qualification, my lord. Earlier, my lord, it was not required.
So that doesn't
no,
count here,
no,
Lordship.
there
My
are,
lord, the
no, no, there are two aspects. So far relating to the qualification, if a person enters into a service with a less qualification, if there is an amendment to rule, you cannot throw him out.
No. You cannot.
But so far relating, you cannot throw him out. He might not get a promotion to the next grade until and unless there is a relaxation power is exercised. So far relating to the age of superannuation, it is you can decide. And Supreme Court in Constitution when states that at any time as you can increase, you can decrease also. The person will have no right that while I am entering into service, it is 62, it should always remain 62. It may be 65, it may be 58 also.
That is the thing. In this case, Lordship, in the service record, it's in the same thing which I'm saying. And then when I submitted my representation, they did not go ahead and set over it. That's why I'm here before this.
So
And
therefore,
there's nothing like determination to be
so
determined.
till date they have not determined,
Oh.
even to examine whether they are correct
Yes.
or wrong. So therefore, let them exercise that option.
And now only 3 years left service. So that the medical board was
But that will not comment whatever. But give the order. We will not do the exercise.
My
Okay.
conviction was that I have given you a representative of such it.
Okay. Dispose of. Dispose. नाम तो लिख रखो हैंडी अगर तू थोड़ा सा अपडेट Respondent number 1. Mr. Anybody appears in this in that case? You are in both of for respondent number 1.
I'm for respondent one, the other is my
Okay.
DC.
Yes, Deori.
Lordship, in this case, I think the zone of consideration for promotion to the post of assistant tax collector. But smoking as a tax collector in Guwahati Municipal Corporation, but I have not been promoted.
Yes,
According to them,
Bora, what you say?
But I keep the instruction, but in the meantime, let her not be.
Who is 1, 2, 3, and 4? Somebody has filed affidavit.
yes, there was
Loni
affidavit,
Borpatra
yes.
Gupta.
It
Deputy
is from
Secretary
the-
Government Assam.
No, it will be from the corporation, madam. The state government has filed a.
Affidavit, right, according to them, your Lordship, there is no service rule.
There is no service to my lordship. There is a representation pending, my lord. Page number 31. Ultimately, the corporate CPC had to take a call in the corporation, not by the government.
It's up to Mr. Deori. You want us to determine or go back to you?
I have filed my representation, your Lordship. They may consider my case because immediately was like
So
me
we
and-
can dispose it of.
Yes, sir.
Yeah, we'll say that you have no grievance if it is relegated to the corporation to determine that. We will not comment on merit.
Page
Only my
30
case to be
page
Ah.
31.
Mr. T. Deori. Heard Mr. T. Deori, Learned Counsel for the petitioner. Also heard Mr. S. Bora, Learned Counsel, appearing for Guwahati Municipal Corporation and who are for the department are Thor. Is it not? For the remaining.
Initialization.
The grievance of the petitioner is aggrieved by non-consideration of his case for being promoted to the post of assistant tax superintendent. Assistant tax superintendent, inasmuch as, according to the petitioner, he has already been promoted to the cadre of tax collector, and he have all required qualification and experience for consideration for promotion to the post of assistant tax. Mr. Deori further submits that being aggrieved, he has already preferred a representation before the respondent number,
Number 3.
respondent number 3, within bracket annexer,
Annexure F page 31, my lord.
Annexure
F page.
Annexure F page 31. Mr. Theory submits that the petitioner's limited grievance is the non-consideration of the aforesaid representation, and at this stage he will have no grievance if a direction is issued to the respondent corporation, respondent number 3, to consider the case of the promotion to the next higher. Mr. S. Bora, learned counsel for the Guwahati Municipal Corporation, submits that the corporation being a model employer, they will definitely consider any representation preferred by the petitioner for consideration of his promotion to the next higher grade, subject to his eligibility and availability of vacancy, and subject to the extent, norms, and procedure. So subject to fulfillment of extent, norms, and required procedure. In view of the aforesaid consensus, this without commenting on, in view of the aforesaid consensus at the part, without commenting on the merit of the claim of the petitioner, the claim of the petitioner for promotion to the next higher grade, this petition is disposed of, directing the respondent number 3 to consider the case representation of the petitioner as well as his case for his claim for promotion to the next higher grade of assistant tax superintendent. Assistant tax superintendent. The petitioner shall also be at liberty to file a fresh representation before the respondent. Such representation, if so advised, be filed within a period of
1 week.
within a period of 10 days from today. And thereafter, the respondent number 3 shall consider such claim of the petition within a 10 days from today. Consider the claim of the petitioner within 6 weeks thereafter. Within 6 weeks thereafter, any determination made in this regard be communicated to the petitioner. It is needless to say that if the petitioner is aggrieved by any of the decisions taken by the respondent, he shall always be at liberty to approach the competent authority. Yes.
On the big defense against that it the date cabinet carry me bit
Who is for the respondent? Any affidavit file?
We have filed a affidavit, my lord.
What is your stand? Now, what you say, Mr. Das, you want the salary back?
yes madam. The salary till the date he was terminated, madam. He was terminated with effect of madam at 12:50 madam. It then madam salary which was getting madam. I have also stated in paragraph 7 madam.
Where is the termination?
That termination letter is at page 46 at 8.
Page 46. Any statement regarding your arrears of salary by them in affidavit?
Here even in my affidavit, it is, we not
No,
take
my
any such stand. We just say that, my lord, we have, he was a contractual employee, unauthorized absence, and we have terminated him as per clause 12.5 that we have stated, my lord.
Without any juvenile inquiry.
Yes, my lord.
That was the
That is what, my lord, the rule says. Without giving just 1 month notice, we can terminate him.
Poor performance is not a stigmatic. There are many that.
How much the
Suppose you say you have misappropriated, then it will be stigmatic. But you've been apprised, then your unauthorized absence, that's okay. Then asked to submit. What was that?
the person expired.
Anyway, this person expired.
Yes, sir. He expired now. His
Expired.
wife is before their birth.
Okay, wife is.
Yes, sir. He was inferior, madam.
He inferior herself.
What is the speech period according to you?
My prayer is that till the date when he was terminated, up to that date, sir.
What is anything, any claim on your
Yes,
behalf?
sir. Paragraph number 11.
Present, just listen to it, not disposing it of. You have instruction whether anything was. Widow has come. If there is anything,
That is what, my lord.
if there is something, okay.
Yes,
If
sir.
not, then no way out. Okay.
Otherwise, also, my lord can dispose it with this directive if there is.
Oh, I do not want to invite a contempt. Unnecessary contempt. And all these contempts are because of non-determination and sending it to you.
My lord, grant me some time, I will.
You have
Right.
it. If you say we'll record it, then we'll give her a liberty. You give her, communicate it to her that no, your husband is.
Small amount.
That's why we do not want you to place in a position where you need to fight. You still remain on a hope and come to this court for a small amount. So you'll have to settle everything for the widow. If your hope is correct, you have it. If not, then we conclude here.
My lord, direct. Person order today, keep it pending, my lord.
No, we are keeping it pending. Okay, Mr. Das on Mr. Hartman. The present writ petition was filed that the husband of the petitioner was husband of the petitioner while petitioner was working as a contractual employee under the state project director ARIAS capital society Khanapara. Full stop. Alleging poor performance and prolonged absence in duty, the contractual service of the husband of the petitioner was terminated by an order dated 30th of November 2021. Full stop. Assailing such termination, order of termination being punitive, the instant petition. During the pendency of this petition, the husband of the petitioner expired and accordingly the petitioner got it. Mr. Das, learned counsel for the petitioner, on instruction submits that so far relating to the termination of contractual service, the petitioner wife is not inclined to pursue the same in as much as that will be a futile exercise. He further submits that, however, the husband of the petitioner was not paid certain amount of salary till his date of termination, and a direction may be issued to the respondent to pay the aforesaid amount to the wife. Though an affidavit has been filed, no specific statement is made regarding non-payment of such salary. In view of the aforesaid, Mr. Dhar, learned counsel representing the employer, submits that he may be granted some time to obtain instruction whether there was any due against unpaid salary to the deceased husband of the petitioner. And if there are further debt can be paid to the accordingly with that 6 rest and sell out, release this matter on. Give a date. It's a short matter.
Short matter. Short matter.
13th of March.
Yeah, can. When that happens.
Okay.
Okay. Here, but after award,
Uh,
but I'll find every otherwise the paid the salary and the
My instruction have not been.
okay, let him file an affidavit so that you can respond. Okay. Mr. D. Nath, Learned Counsel submits that the provision of section 17 within 17 dash capital B of the Industrial Dispute Act 1947 has already been complied with, and required payment has been made to the respondent number, to the sole respondent. However, MSM Kechi, Learned Counsel, representing the sole respondent, submits that she has instruction that the respondent number 4 has not received any such amount. In view of the aforesaid, Mr. D. Nath submits that he may be allowed a week's time to file the affidavit. File an affidavit to show that due compliance of section 17B has been carried out. Accordingly, prayer of adjournment is allowed. Please this matter. 15. You give a copy to.
Yes.
So that 15th.
I'll
You go through it, have a call. If there is some proof of payment, look in. Yes. Yes.
Lordship, here, your lordship, advertisement for the post of Ganpati Ghat was made, your lordship.
Hmm.
Without showing the, it was actually your reserve category, your lordship.
Okay, we understand, but who will file affidavit?
We will file affidavit, my lord.
When?
My lord,
21.
my lord,
Or now let us slowly forget those days. That 17, 18 meters are no affidavit. You are here.
yes,
You will file it. When?
my lord.
After 2 weeks?
2 weeks.
Okay.
No, my lord, what happened actually, though it's a matter of 21,
Hmm.
the copy was served upon us after 14/23.
Okay.
Last order reflects that.
Okay.
That is why.
Mr. Ardhar, Learned Counsel, representing the private, representing the respondent number 1, 2, 3, 5,
All
the standing council, WPT and BC department.
I will appear for both, my lord.
Talk about Learned state appearing for the state respondents. Praise for and is granted 2 weeks time to file affidavit.
My lord will take
3 weeks. 3 weeks time to file affidavit. Okay. List according. Yes.
This is regarding the non-payment of the minimum wages to the casual workers, your lordship. Pursuant to the defense and judgment is entered in Upendar, Table 45 of 14. The government created 2 lists. One is pre-AFRPM and the post-AFRPM. AFRPM means Assam Fiscal Plan. And the cutoff was 19/2005. Those who are in the pre-AFRPM state, they will get the minimum of the
Scale.
pay scale. We are all before 19/2005. But unfortunately, while submitting the check slip, our date of joining was wrongly. So your lordship examine our case. Similar case.
We have received the certain disputed factor.
Yeah, let them
You
examine.
consider. You consider their disputed facts. We cannot.
what we have found, we have conducted an inquiry, we have found that there
There
are
are
no records of their appointment in the under PNRD.
Okay.
If no, our case may be rejected. There are 5 here.
Okay. You are
U Sharma,
U Sharma on behalf of. We'll give them a chance to file it. U Sharma,
on behalf of Mr. K. Kumar,
Mr. K. Kaur, learned
Senior Standing Counsel,
standing counsel. Praise for and is granted
4 weeks.
4 weeks time to file a petition. List according.
Highly
Also, the deputy commissioner
Okay.
can.
The learned counsel for the petitioner prays for an adjournment to take appropriate steps. That is allowed. Click after quick. Just handy. Just
I'm trying.
yes, but what about Mr. R.P. Sharma's case? What happened?
My lord, I have received an instruction regarding only this progress of appointment is not done and present status is my lord is pending.
Okay, you
Pending.
ask. Okay, we're just recording it.
One more thing, my lord, let him bring the record, my lord, since there is an order of date is 6/22 for police of record. It can be disposed all within 50 days or so.
Okay.
Not matter.
My lord,
This
I will get that.
okay. This IA is filed for this interlocutory application is filed for the heart Mr. R.P. Sharma, learned counsel for the applicant, learned senior counsel for the applicant, assisted by A. Decca, and also Mr. R. Learned counsel for the present application is filed for present IA is filed for praying and praying for an order of staying the operation of an advertisement dated the advertisement dated
Till the 1st January 2024.
advertisement dated 1st of January 2024.
I think there is
What?
no date discussed, I think.
No, that is 1st of January. No, that is something different.
Different.
Come on. An advertisement whereby staying the operation of an advertisement whereby operation published in Yugosankha e-paper whereby application for filling up of the post of community organizer under under
Mission management.
City Mission Management Unit under CMMU, capital CMUU at Hailakandi under Assam Urban Livelihood under Assam Urban Livelihoods Mission Society within bracket ASULMS all capital bracket close IA page 8. Okay, underline. The connected writ petition was filed assailing the termination of the petitioner from her or his her contractual service of community organizer at Hailakandi under CMMU. During pendency of this of the connected writ petition, an advertisement was issued for filling up of the said post. Isn't it?
Yes, on 3/2/2021.
On 3/2/2021. However, this court, under its order dated 19/2/2021, passed in the connected writ petition, directed the connected writ petition, as an interim measure, directed that the post of community organizer vacated by the petitioner shall not be filled up till the next returnable date. Subsequently, such interim order was extended until further order. Were extended. As there is already an interim order, this court sought instruction from Mr. Ardhar, learned counsel, for representing the respondent. On instruction, Mr. Ardhar, learned counsel, submits that when advertisement has been issued, however, they have in view of the interim order passed earlier, the respondents are not proceeding further with the election process. Mr. Dhar further submits that the matter may be taken up for final disposal as one important position is directed to be taken. Mr. R.P. Sharma, current senior counsel, also agrees that instead of taking up all this interim matter, by clarifying that there is already a stay order, the IA can be disposed of and the writ petition can be taken up for final. Considering the matter entirely and clearly in view of the submission made by the learned counsel, Mr. Ardhar, that they will not proceed with the selection in view of the earlier interim order dated 19/2/2021 passed by this court, the IS stands closed. The petitioner shall be at liberty if such consensus is not necessary. Already is not. IS stands closed. Writ petition registry to list the connected writ petition in the admission stage, in the admission column. When March, when 22nd of March 2024. Where is the order? Where is the order?
Order there is 6/6/2022, my lord, record
6/6, or you said that some record? 6/6?
2020.
Okay.
Otherwise, we file our affidavit.
Okay. It's not part. Writ petition. The interim order passed earlier on 19/2/20 is extended until further. The Mr. Ardhar, learned counsel for the respondent, submits that the respondent has already filed an affidavit and he will be in a position to produce the record on the next date of hearing in terms of this court's earlier order dated 6/6/21.
22.
6/6/2020. Please this matter on that part. Let me like. We will decide that.
Yes. File it.
A limited issue, contractual appointment, what is her right and where the way of terminate. That's all. That's all, yes, Mr.